Okay, so you're 1/3 done. How's it going?
Oh my God. My brain hurts.
How many hours a day are you putting in studying?
23.
Basically.
How much caffeine are you drinking?
Too much.
How many of you are taking Adderall?
Not yet.
I wouldn't. Where do we get that again? Was that an offer?
No, we've had to put at least one student on medical leave for taking Adderall during exams and having a really bad reaction.
Oh, wow.
If it's not prescribed to you, do not take it. Yeah, we had to take him to a mental hospital. The second time he did it.
Wow.
So, my advice to you, unsolicited, is get a good night's sleep before you take the test. And drink plenty of water. Your brain is a hydroelectric mechanism. If you are as little as 15% dehydrated, you will lose over 25% of your logical function. Which is not a good thing on a law school exam, so you'd be able to think. So between now and Monday, drink plenty of water. Get yourself hydrated. Now, what else I've told you all my wisdom. What else can I help you with?
Review
Review, what do you need to review?
everything.
Law purpose.
I just was wondering if you can kind of guide us on how to approach this as far as, because there's so much information and there's a lot of law in it, so I was wondering maybe you can help us narrow it to what we need to focus on each section possible.
Well, that is what you need to do. You need to be figuring out as you study and as you write your outline and as you delete things from your outline, what is it I need to focus on, what is really important. So I can just tell you, you should be able to move from a 40-page outline down to a 30-page, down to a 20-page, down to a 5-page. You need an outline that you can walk in and write in the margins as soon as you see the exam and you see what the issues are. You need to be able just to write your outline down. And then you won't miss anything.
That's a C.
I have no curve. You need a C+ in this school.
I've been spending a disproportionate amount of my time studying the law of perpetuities.
I wouldn't do that.
That's what I was going to ask.
I wouldn't do that. I would focus not on the smaller, but on the larger. And I will just tell you, present state's future interests in the rule against perpetuities are being tested by way of multiple choice only.
What did it say again, ma'am?
Present states and future interests in the rule against perpetuities. The last chapter that we did will be tested by multiple choice, but not by essay.
Thank you, baby Jesus.
Well, don't thank me yet. There's a lot on the multiple choice. So, but again, the multiple choice are worth 4 each. You've got 27 multiple choice questions.
You say 40? Oh, how many multiple choice professors?
There are 27 multiple choice questions. They are worth 4 each, which gives you and they're graded on a 100-point scale, which means I'm spotting you 2. As long as you get 25, you get a 4. It goes down from there. That's a third.
Professor, how much time would you allot for the multiple choice?
I would not allow, well, my suggestion is they're worth, I wouldn't do more than an hour.
1 hour for multiple choice, so 2 hours for the essay?
There are 2 essays, which should be about an hour each.
2 essays an hour each.
An hour each.
How many issues would you say roughly are on each essay?
I wouldn't say.
For the essay, are you looking for specific form like IRAC, PREAC? or can we
I
just
am
do
looking
our own?
for, you will see on the exam, and if you look at a couple of the exams that are posted, my instructions are always the same. I want it logical, I want it well-written, I want it well-organized, I want it to go from point A to its conclusion without my having to turn back the page, reread a previous paragraph. I just want to go down and check mark. That's an easy A. All I do is nod my head and do check marks. If I'm doing anything else, the clock is moving down. If I have to stop and try to figure out what this word is, if I have to correct the grammar before I can understand the sentence, if I've got repetition going on, cut and paste is fun, right? It's not fun for me. So, write well. Write it the way a lawyer would write it. That's what we're looking for. Can I look out there a year and a half from now, 2.5 years from now, and see you people practicing law? When I'm looking at this.
Why are you laughing? Why are you laughing? You look right at me and laugh.
That wasn't on purpose.
I wasn't looking at you, Mr. Kirkland, but you may take it as you like. Okay. So, that's enough about the exam. I consider it to be pretty easy for you to be able to do a really good job on it. Really. And I'm really looking for how well do you put this stuff together, how well can you analyze. So, are you clear about trespass? Feel good enough about what the elements of trespass are?
Could I clarify the elements of trespass?
Yep.
Unprivileged, intentional intrusion on the property, possessed by another.
Right, we usually say invasion of the property, a property possessed by another, that's correct. And you need to be able to, distinguish that from nuisance, which is use of your own property in a way that interferes with your neighbor's use and quiet enjoyment. Trespass protects the right to possess the property. And we talked about a number of exceptions to the general rule that I have the right to exclude anyone from my property as an entitlement of my ownership. However, we looked at cases in which we say the more that the premises is open to the public, the less we protect the right to exclude. And there are some times that we prohibit exclusion.
Those are exceptions to possession?
Those are exceptions to the general rule, which is my home is my castle. And it's absolutely up to me who comes and goes. And we looked at a number of cases in which the farm, how open is the farm to the public? Not very. So we create a narrow exception that says that the lawyers and the social workers can come on to aid the farm workers, but that's it. Farmer retains the right to exclude everybody else. We move on to places of public accommodation, restaurants, inns. We looked at the common law rule that said common carriers could not exclude unless the customer was disruptive, that inns had to accommodate, had to give rooms to anybody who came along unless there was something dangerous about the customer. Hands up?
Oh, yes. Do we need to know the case names or, do we need to know the case names?
You tell me. Does it help you to know them?
No.
I'm content if you can give me the rule. I'm impressed if you can talk about a case, but the exam is not constructed so that you are being asked to draw analogies between one case and these facts. Because in property, we're talking about the common law, and we're talking about multiple jurisdictions. You're just learning the general law of property, so any particular case, unless it's a Supreme Court case, is not necessarily going to be relevant.
So the black letter law, and then is our application of the facts, and synthesizing that
With the rules.
is sufficient enough.
Well, don't put it down. It's a hard job. If you do use the cases, cite them correctly. Don't make me go look it up and find out that you told me the wrong name. Okay.
So in the,
We also took a look at the Handicap Act, if you remember.
Yeah, AC.
Another exception to the right to exclude. We took a look at 1981 and 1982 of the 1864 Civil Rights Act, 1866 Civil Rights Act, that protects the right to contract and access to property. Says that everybody enjoys the privileges of white citizens. And we took a look at Title II, I think, places of public accommodation, which was the Civil Rights Act passed shortly after President Kennedy was assassinated in 1964.
President Johnson, sorry.
President Johnson.
Was it Johnson that did that?
Yes.
Yes.
Johnson was president when the Civil Rights Act of 1964 was passed, when the Fair Housing Act was passed in 1968, which is another law we will be looking at next semester. In all of those laws broadly, we talked about the fact that for a while there was a point at which private actions to exclude persons based on race could not be reached by law. Because the Supreme Court said 1981 and 1982 don't reach private action, and there wasn't any other law that allowed it until the Civil Rights Act of 1964. After which the Supreme Court said, oh well, we might as well say 1981 and 1982 apply to private actions as well. So now we have lots of law.
And 1964 just covered the 4 protected classes: race, color, religion, and national origin.
Yes, with respect to access to property. Another part of the act included sex. Title VII.
Would you say there's 2 things need to prove discrimination, and those are an immutable characteristic and a history of discrimination?
That's what makes it a constitutionally protected class. That's not what makes it a statutorily protected class. Congress can protect any category, but generally we protect classes of individuals based upon a history of discrimination against a person for having immutable characteristics.
So the exam, and I missed part of that class, but if you have, like, let's say it's a white person being discriminated against, are they part of a protected class?
Yes,
They don't have a-
race is a protected
So
category.
all races, so no matter what the exam says as far as the person.
Well, the law is structured in terms of may not exclude based upon race, and that has been interpreted to protect white persons as well as members of racial minorities.
Okay.
That's what the reverse discrimination cases are. But in terms of what the Constitution protects, or what Congress typically says it's protecting, we're looking at history of discrimination based upon something that you can't do anything about.
Public trust doctrine?
Public trust doctrine. The beaches of the country, the coastline of the country, belongs to who owns it?
We the people.
We the people, represented by,
Government?
God help us, our government, yes. And our government, our sovereign, owns the coastal area. The sovereign has ceded to the various states that have coastal boundaries the right to administer the public trust doctrine. So there's a Georgia public trust doctrine, there's a North Carolina one. They all are essentially the same thing. The public trust doctrine was developed to protect navigation and fishing, so that the states were not, no one is allowed to make it impossible to access the beach from the water. And the doctrine is imposed upon the land that we call the hard part of the beach, mean high water mark. It is the obligation of the government to administer this portion of the beach for the public, in the public interest, for the public good.
Professor, what about free speech rights and access to private property? Pursue that on the show?
Well, what is the rule? Do I have to let people come into my business establishment and talk any way they want to?
Well, there are 3 cases, it kind of depends.
If my premises is a company town, and I own everything in it, including the fire department and the school system and the police department, and I function as the government, essentially, then I have constitutional obligations to the people who live in my town. That's one. What's another one? What's another exception? Is there another exception? Sometimes administrative agencies say that your right to exclude persons based upon their speech is trumped by another statutory right. For example, the National Labor Relations Board can order an employer to admit union organizers to their premises under certain conditions. It is seldom done, but it is possible. But other than narrow exceptions like that, you basically have a right to exclude people, to regulate what people say on your property. And that includes political expression such as leafleting, picketing, so forth.
That's the rule under Lloyd. Private business may constitutionally exclude the distribution of handbills on its property.
Correct.
So to clarify, Lloyd, I had a shopping center is not equivalent to a public square, and First Amendment did not require the shopping center to allow leafletting on the premises?
Correct.
Okay.
Now, not all of the states agree with that. So we'll see, next semester, we'll see a case from California. California says everybody's got a right to run off at the mouth anywhere, any place, any time, including at the shopping mall. But for your purposes, as far as the federal constitution is concerned, there is a right to exclude. Now, if it's a public forum, that's where the free speech rights attach. We're generally talking about government-owned property. The sidewalks, the streets, the courthouse square, and other places where people gather to petition the government for redress of grievances. Anything else on that chapter?
Correct.
So, percentage-wise, how likely is it that we have an adverse possession issue?
You're all praying for it, aren't you? But you know adverse possession cold.
Maybe not.
Adverse possession is easy. So you can guess, your guess is as good as mine, whether it's on there. Everything's on there one place or another, pretty much. I mean, that's the nice thing about multiple choice questions, you get a lot of coverage.
So am I wasting my time studying adverse possession?
No, though I would think you know it. I mean, don't you feel fairly comfortable about these chapters?
Which one?
Until
we get to the last one.
Right.
I mean, adverse possession, is everybody pretty okay with it?
I'm not, I can't identify the chapter, but can we go over the cases where we were talking about, like the house that was on the mountain and what duty the neighbor owed?
Subjacent and lateral support, which I think we did in the nuisance chapter.
Before we move on from adverse possession, are you going to hold us to the Georgia or the common law standard of years?
20 years versus,
20 years, or I think Georgia's got a less debt.
Georgia's 20 years.
If you are going to be using a particular state set of statutes, You will be told that, and you'll be told what it is.
Okay.
Just know there's a prescriptive period. It's 10 to 20 years. But you know, if I give you a problem where there's 15 years, and you're going to have to be told what's the prescriptive period, so don't worry about that.
Can you memorize the Georgia codes for those nuisance provisions?
I wouldn't think so. I mean, I gave you the Georgia codification of nuisance just so you'd see how Georgia does it. It's essentially a codification of the common law that you learn. Uses a little different vocabulary, but what are we looking for in nuisance? Substantial and unreasonable interference. It's unreasonable interference and substantial harm. You need to be able to say it's a nuisance because it causes substantial harm and because it is an unreasonable interference with good use and quiet enjoyment of the property.
I have, if you can clarify something for me. Under the Dobbs case, it went through the nuisance analysis and then it touched on how to figure out whether the defendant needs to modify or cease the activity. So it had maybe 5 prongs for that. And then the notes tell us the fairness and welfare part of it. So do we need to know both, or do we need to know just the fairness and welfare analysis that the casebook provides us?
The short answer is know what the notes tell you, what Singer's sort of composite is of all this. But in fact, where is it that you go off onto this other 5-point analysis?
It talks about modification or the case itself, the court, the way they analyzed it. They said whether the defendant was engaged in a useful activity, whether...
Right, that's when we're talking about unreasonable interference. Then we look at how useful is what the defendant is doing. Has the defendant brought 300 jobs into the community, in spite of the fact that it's creating a nuisance? How useful is this activity balanced against how useful is the plaintiff's? And it's a, we frequently say both are useful. Who's in the best position to correct the nuisance is another question about where is it fair to make the defendant abate this nuisance? Or is there something that the plaintiff can do? Did I give you the problem of the 4th of July party that was annoying the neighbors? So we have a 4th of July party and it gets out of hand. And the next door neighbors complain because there's litter on their lawn the next morning and everybody's carousing and keeping them up late. And so the question is, what do we do about this? Is it a nuisance? So is it a substantial harm to them on that day? It could be a temporary nuisance. But in fact, if we decide that it looks like they're being interfered with, who's in the best position to correct that? Do we tell the defendants they can't have their party? Or do we tell the plaintiff, go get a hotel room and let the defendant pay for it? These are some of the remedial options you can take, because remember, the goal is to allow the defendant to use his property as much as he wishes, so long as he is not creating a nuisance. So we don't restrict him any more than we have to abate the nuisance. And sometimes if the defendant's activity is extremely valuable to the community, we let the nuisance continue, and we provide a damage remedy instead. We make the defendant buy the houses around the cement plant, remember, so that the people who lived in them could move away. And all that has to do with unreasonable interference. So analyze first whether there's harm, substantial harm, and remember, that raises the issues of hypersensitivity. Is it substantial harm. Harm is offense that would be taken by a normal person. Not usually even a reasonable person. We're not normally reasonable.
Is it normal use of land?
And what kind of use of land is it that's creating the nuisance? And remember, there's always this factor, if all of the factors balance out, there's substantial harm, we can't tell quite what to do. Who came first tends to decide the question. We protect the first use if they are incompatible. More on nuisance?
Do we need to discuss the intentional and negligence aspect of this, or just the substantial harm?
I would not bother with the intentional or negligent side of nuisance. Basically, it's an intentional tort, it's the intent to do the act. Or reckless disregard of the fact that the act is going on is another way of looking at it. So just be aware, I mean, if I go off and leave my property for 5 years and it becomes a drug house, did I do it, did I intend for that to happen? But is that recklessly negligent of me to do? Either way, I can be liable for nuisance. And that's, so you need to analyze the facts you have. You need to be aware of that. I don't need the rule, I need which rule applies here.
So you just told us that you want us to discuss majorly substantial, the harm and the unreasonability that's involved. You gave us 3 prongs for substantial harm. What do you want us to discuss specifically under unreasonability?
We just talked about what's unreasonable interference. One question, one analysis is there substantial harm?
Oh, so it's this.
If we can say there's substantial harm, we can't say there's substantial harm, we throw the case out at that point. If we can say there's substantial harm, we go ahead and say, is the interference unreasonable? And that's the more complex analysis. And that includes, is it fair to make the defendant pay? What is it fair to make the defendant pay?
If you come to the nuisance, then I know that you can't make it stop. But if you come to a nuisance and then over time, whatever that activity is, like increases, you still not have a right.
You may.
Okay.
The doctrine of coming to the nuisance, again, that's just the sort of backwards way of saying first use is privilege.
Okay.
If I'm already operating my hog farm, and it's stinking up the world, and it's been doing that for years, and you put your development downwind of me, then you came to the nuisance. You knew it was there when you came. And so you should not be heard to complain. You know, you shouldn't be able to move here, build your development, and then make me shut down my farm. So again, we're protecting the prior use. And a lot of states have right to farm statutes that do precisely that. Georgia's one of them. Most of the states that have a lot of agriculture protect farms from nuisance claims. But good point about that other aspect of nuisance.
Can we answer Tia's question about the support?
Oh. That was a while ago. Yes. So, lateral support. What is my duty to my neighbor with respect to lateral support of the property? Remember, that's the vertical support.
To give it.
Provide and not be negligent.
I must provide lateral support to my neighbor's land in its natural state. I have a strict duty. If I take away the support and do not replace it with an artificial structure, I am liable forever for anything that happens, no matter if I sell the property.
And that's
I
strict
stay liable,
Strict liability on that?
Yeah.
strict,
Did you say no matter if you sell the property, so
no
the
matter.
new owner is not?
That's if I have not replaced the support.
If you have not replaced the support, sell the home, new owner is not responsible.
Right.
You remain property.
I'm still responsible. If I do replace the support with a retaining wall or with some kind of wall, I create an artificial structure, then the obligation runs with the land. And successive owners, I can pass my liability on if I have provided an artificial support. So it behooves the landowner to provide the artificial support. It's the only way to get out of the strict liability issue. Once there's a wall, then successors are obligated to maintain it so that it supports the neighboring property in its natural state. So what about structures?
Not liable to the structures built on.
No strict liability for the structures, structural damage. I'm not obligated to support my neighbor's structures, just the land in its natural state.
Isn't there, unless the support was the reason why the land gave in and the structure, then because of that.
Correct.
they can't.
If in fact the failure of lateral support causes the land in its natural state to subside, and that would have happened even if there hadn't been a house on it, then I will be strictly liable for the subsidence of the land and the damage to the house. Right. Otherwise, the standard is negligence. Have I removed lateral support from my neighbor's structures in a manner that is negligent? It's not strict liability now, but we have to give reasonable notice to the neighbor that we're about to excavate or that we're about to take down the wall. And we have to conduct the excavation carefully. So it's a two-pronged standard, both with respect to did I tell you I was going to do it and did I do it carefully.
I'm assuming when you have to give notice, it would have to be actual notice. You need to.
Call them up and say, we're about to start blasting. You may want to put up your own support here. And what you're trying, you have to be reasonably considerate of your neighbor, and you need to give them time really to provide their own support. If you're going to remove support or create a possibility that you're going to excavate and collapse their land, then they need time to put up a scaffold or whatever they need to do. So your obligation is to behave reasonably toward your neighbor. You're going to do an excavation that may affect their support. Subjacent support is horizontal support, and there we're usually talking about extracting minerals or water or oil from underneath the surface. Remember, we can split up ownership so that we sell the coal-bearing part of the property to the coal company but retain the surface. And then the question is, can the coal company eliminate the seam, which will cause our property to fall and sinkholes to appear, terrible things to happen. So the obligation for subjacent support is also strict when we're talking about coal and other hard minerals, because we can leave enough underneath to keep the land above from subsiding. It's a more difficult question with water. And remember, we had the case in Texas about extracting the water so that the land was subsiding into Galveston Bay. And the court said unless the extraction of water, percolating water, is malicious, wasteful, or negligent, then the property owner is free to extract as much water as he wants to,
So,
even if it's collapsing wells on the neighbor's property.
so is that the rule? I thought a later case went on and said that they have to be reasonable.
Well,
Is it-
not negligent is reasonable, right?
Would you mind giving an example where it's reasonable even if you're sinking your neighbor's, or negatively affecting your neighbor's land? If it's reasonable because I'm using the water for drinking water, yeah, that's reasonable, but.
Yeah, I'm not selling it. I mean, it's just I've got an artesian well, your well doesn't go down as far. You know, maybe what you need to do is drop your well lower, but all I'm doing is actually, I have a better well than you do. That will sometimes sink wells.
And there's no cap, I can continue to do that even if it negatively.
Right. Can't do much of anything about that unless we can say it's being maliciously extracted, I'm trying to sink your well. Or I'm just letting it run all over the ground, which is wasting it. Or I have somehow or other negligently constructed my well.
And I have three theories on that. The absolute ownership theory, the landowner may make use of any of the water. The reasonable use theory, landowner may make use of it does not reasonably interfere with the neighbor's use of water, and the relative rights doctrine, the landowner may use a proportionate share of water. Which one do you want us to?
Well, the rule is, I mean, the academic doctrines aside, the rule is you can use percolating water without worrying about what happens to your neighbor. You can use it in unlimited amounts, so long as you're not wasteful, malicious, or, and in Texas, negligent. The old rule was waste or malice. The new rule is waste, malice, or negligence. But most states have probably not adopted it, though they're likely to.